Can a person who converts to Christianity continue to claim Scheduled Caste status? A routine criminal defamation case involving allegations of insulting Hindu deities and promoting enmity has morphed into a constitutional flashpoint over religion, conversion, and reservation. Hello, this is Ruchi Bhattar, and let's look at a recent order of the Allahabad High Court delivered by Justice Praveen Kumar Giri that has brought back the focus on this issue and led to sweeping statewide administrative directives. First off, what's the case about? Jitendra Sahani was accused of using filthy, abusive, and absurd language about Hindu deities, mocking Hindu rituals in Hindi, specifically how someone has 8 hands, someone rides a mouse, someone drinks bhang, and someone does ganja, highlighting caste divisions and promoting Christianity by claiming it brought jobs, business growth, and healing, and Arthik Labh. The case started with Jitendra Sahani's plea to quash proceedings under IPC sections 153A, focusing on intergroup hostility, and section 295A, targeting insults to religion itself. Sahani had obtained prior permission from the subdivisional magistrate of Maharajganj to preach the words of Christ to public at large on his own land by moving an application, and installed a tent at a public place where he used to organize prayer meetings of Christ amongst large number of people and tried to convince them about accepting Christianity, which necessitated cancellation of permission and sanction for prosecution under IPC sections relating to promoting enmity and outraging religious feelings. Beyond IPC allegations, the High Court took serious note of Sahani's contradictory religious declarations, the fact that he swore on court affidavit that he was a Hindu. It held that such discrepancies may indicate forgery or an attempt to unlawfully retain Scheduled Caste benefits after conversion. While dismissing Sahani's plea to quash proceedings against him, the court issued statewide directions aimed to ensure that what the Supreme Court terms prevents fraud on the Constitution. The district magistrate Maharajganj was instructed to inquire into Sahani's religious status within 3 months and take strict action if forgery is established. All district magistrates in Uttar Pradesh were directed to ensure within 4 months that Christian converts are not continuing to claim Scheduled Caste benefits. The Chief Secretary of UP, the Cabinet Secretary of the Government of India, and the Principal Secretary of the Minorities Welfare were also instructed to prevent the conflation of scheduled castes and minority statuses. But what does the Constitution say about this disputed religious identity? The pivotal issue arose when the court noticed a glaring contradiction. While the police witness stated that Sahani, originally from the Kevat community, had accepted Christianity and held the post of a priest, Sahani's sworn affidavit before the court listed his religion as Hindu. This inconsistency triggered a constitutional red flag pointing directly on the limitation of the Scheduled Caste status under the constitutional framework. Under paragraph 3 of the Constitution Scheduled Caste Order 1950, it says that no person who professes a religion different from the Hindu, the Sikh or the Buddhist religion shall be deemed to be a member of the Scheduled Caste. This provision remains the anchor of the legal position. Conversion to Christianity terminates Scheduled Caste status. The High Court underscored this clause, also referring to Section 2 of the Hindu Succession Act, which includes within the term Hindu anyone who is not a Muslim, Christian, Parsi or Jew unless proved otherwise. A Christian convert, by this logic, clearly falls out of the definition. The constitutional scheme has been repeatedly affirmed in judicial interpretation across decades. In Susai v. Union of India 1986, the Supreme Court held that a person belonging to an SC community loses eligibility for SC schemes upon converting to Christianity. This position was sharpened further in C. Silvarani versus Special Secretary 2024, where the court held that claiming caste-based benefits after conversion amounts to a fraud on the constitution. The Andhra Pradesh High Court this year ruled that SC status stands nullified upon conversion since caste discrimination is not recognized within Christianity, irrespective of the existence of any previously issued caste certificate. The court further held that the SC/ST Prevention of Atrocities Act is intended to protect communities that historically face caste-based discrimination. Consequently, its protective provisions cannot be extended to persons who have embraced another faith wherein the caste system is not recognized. The Karnataka High Court similarly held that extending SC/ST Act protections to Christians is impermissible because the Act exists to address caste-based discrimination, something that does not exist within Christian theology. Together, these decisions reinforce the central principle that SC status is not tied only to caste origin, but to the experience of caste-based social disability, which legally disappears upon conversion to Christianity. With that, thank you for watching.